Take your seats, get your piece of paper, ball pen, bawal mag-cheat. Eto na naman tayo sa ating weekly quiz. And I'm your quiz master sa Legal Advice Corner. Usual mechanics. Meron tayong topic for today. Patapos na po tayo sa alphabet. So, we stopped last week sa letter T. So, nasa Glossary of Legal Terms tayo. So, we're gonna recommence with letter U. And I will state U, V, W, X, Y, Z or Z dito sa UK. Terms, legal terms and their definition at huhulaan nyo po kung totoo o haka-haka lang or myth ang statement na yon. Siyempre, kulang, 6 na lang yung natira sa alphabet, so we have to put bonus round. Ang bonus round, Latin term. So I have a handful of Latin terms, 4 ata, o 5 Latin terms. I think it's just 4 Latin terms. At huhulaan nyo, legal pa rin, in a legal context, so Latin terms that you will hear sa batas o sa korte, at huhulaan nyo po kung ano ang meaning. Or I will say a statement containing those Latin terms, at huhulaan nyo if it's truth or myth. Without further ado, number one, it's the letter U. Ultra-virus. Ultra-virus means an extra judgment of the court. Truth or myth? Ultra-virus. So yan daw ay extra o bonus na judgment ng korte. Truth or myth? Number 2, letter V for vacant possession. Means that a property which is sold with vacant possession must be empty of existing tenants or other occupiers, and all goods and rubbish or trash that substantially prevent or interfere with the enjoyment of a substantial part of the property on or before what we say here is a completion of the sale of the property. So vacant possession, sa madaling salita, walang tenant, walang goods, walang basura na makaka-interfere sa pag-enjoy mo ng property na binili mo at completion of that sale. Completion meaning, nag-change na yung pera, nabigyan ka na ng mortgage, napasa na, nag-remit na ng mga pera sa isa't isa. Number 3, letter W. Without prejudice. Without prejudice is a term used in UK law to describe statements made in a genuine attempt to settle a dispute that cannot be used in court as evidence against the party that made them. Truth or myth? Letter W for without prejudice. This is now a term to describe statements. So statements na may nakalagay na without prejudice, because yun daw yung mga statements na may nakalagay na attempt to settle. So they may put something in there na ayaw nilang magamit sa korte as evidence against the party that made them. So bawal daw gamitin. So anything without prejudice is kung ayaw mo makita ng korte pero nagtatry ka makipag-areglo. So you may say statements, you may say something. Yun daw ang without prejudice statements. Totoo ba o haka-haka lang? Number 4, meron tayong letter X actually. Letter X for Sidious agreement. I will spell that for law students na nanonood. Sidious is X-Y-D-H-I-A-S. Sidious agreement is an agreement reached between you and your spouse in relation to your financial arrangements on divorce, which is not yet a court order, but you have been bound to. Serious agreement. Ito daw ay agreement na nagkasundo na kayo, pero hindi pa court order, but potentially pwede kang mabound nito. A serious agreement. Okay? Letter Y for yardstick of equality. It means that all matrimonial cases or financial matrimonial cases must be awarded with a 50-50 division. So yardstick of equality means that in matrimonial cases, it must always be 50-50 daw ang hatian. Totoo ba? O haka-haka lang? Or myth? Number 6 for letter Z, or so United Kingdom, we call it Z. Z for zoning. It's a term used in non-occupation proceedings for splitting the areas of the house to manage the occupation of two separate spouses so they avoid conflict. Z for zoning. So yan daw ay a term we use as lawyers in non-occupation proceedings para hatiin yung bahay, to manage yung occupation, yung to manage ang pagtira ng dalawang tao na separated pero andun pa rin sa isang bahay para hindi sila mag-away. Totoo ba? O haka-haka lang? Well, ubos na po natin yung ating alphabet, so we'll have to go to the Latin terms now. Actually, I just didn't realize yung Latin terms pala natin is also alphabetical. So letter A for a Latin term, ad hominem. Ad hominem is a perfume. Truth or myth? Number 8, letter B for Latin term, bona vacancia. I spelled this bona, B-O-N-A, vacancia, V-A-C-A-N-T-I-A, means vacant goods and is the name given to ownerless property which by law here in England and Wales passes to the crown, who is King Charles III. Bona vacancia. Ito daw yung walang vacant goods na walang may-ari. And by law daw ito ay mapupunta sa aming hari na si King Charles III. Number 9, caveat emptor. So caveat, C-A-V-E-A-T, emptor, E-M-P-T-O-R. It means empty goods. Is that truth or myth? And number 10, for letter D, de minimis. In relation to the law, de minimis is translate to the law cares not for small things. Is that truth or myth? So de minimis daw hindi na sasakit, hindi na sasakit ang ulo ng law, they won't consider small things. That's pretty much the direct translation. Totoo ba o hindi? Truth or myth? Actually, may longer yan. In relation to the law, the term de minimis is taken from the extended Latin phrase de minimis non curat lex, which translates to the law cares not for small things. Totoo ba yan? That the law will not really consider small things? Totoo ba? O haka-haka lang? Right, very, very quickly, we will go through it one more time. So if you're just joining us, kung late ka po, sige lang, pasok lang, get a piece of paper, and we will repeat all 10 statements, part 3, from U to Z, and then some legal Latin terms. Number 1, ultra vires means an extra judgment of the court, truth or myth. Number 2, vacant possession. Property sold with vacant possession must be empty of existing tenants, goods, or rubbish that will prevent the enjoyment of a property at completion of the sale of that property. Without prejudice, W for without prejudice, is a term used in UK law to describe statements made in a genuine attempt to settle a dispute, but this cannot be used in court as evidence against the party who's made them. So, pwede pala yun? Pwede ba yun? Truth or myth? Number 4, Xydias agreement, which is spelled as Xydhis, although it is pronounced as Xydias agreement. A Xydias agreement is an agreement reached between you and your spouse in relation to your financial arrangement on divorce, not yet a court order, but which you have been bound to. Totoo ba yan? Pwede ba yan mangyari? Truth or myth? Number 5, yardstick of equality. It means that all matrimonial financial cases must be awarded 50-50 division. Totoo ba yan na always 50-50 division because of yardstick of equality? Number 6, for Z or Z, zoning, a term used in non-occupation proceedings for splitting the areas of the house to manage the occupation of 2 separate spouses so they avoid conflict. Number 7, now in legal terms, ad hominem. Is that a perfume? Truth or myth? Number 8, bona vacancia means vacant goods and is the name given to ownerless property, which by law passes to the Crown or King Charles III currently. Number 9, caveat emptor, empty goods, truth or myth? And finally, de minimis, which is, sabi, short version of de minimis non curat lex, which translates now, the law cares not for small things. Truth or myth? Right. Exchange papers. Si Derek, alam ko, nag-check yan ng mga papel ng mga ibang viewers. So, exchange with your seatmate there or self-checking. Honesty is the best policy. Without further ado, number 1, answer sheet na tayo. Ultra-virus. U for ultra-virus means an extra judgment of the court. That is a myth. Hindi po yan ang meaning ng ultra-virus. Ultra-virus is normally used in company law. Ultra-virus means beyond the powers of the company, or it could also be used, I think, in court proceedings as well, which is beyond the powers of the court. So ultra-virus just means na lumabas ka dun sa powers na dapat lang nasa sa'yo. So, it's also actually within the organization, ultra-virus. It means beyond kung ano lang yung allowed na powers sa'yo. Okay? So, hindi po yan meaning may extra o bonus judgment yung court na parang additional credit sa movie. Wala pong ganon. Number 2, vacant possession. Property sold with vacant possession must be empty of tenants, goods, rubbish that may interfere with the enjoyment of a property on or before completion. That is true. So, when you buy a property here in the UK, normally, makikita, sasabihin po sa inyo, vacant possession. I must insist on vacant possession. Ibig sabihin, hindi nyo po pwedeng iwan yung sofa nyo, hindi nyo po pwedeng iwan yung asawa nyo, hindi nyo po pwedeng iwan yung rubbish. You know, sometimes is nandun yung skip na tinatawag namin, yung napakalaking nandun lahat ng mga rubbish nyo. So that's not vacant possession. So you will see there sa agreement, you are required to give up vacant possession. Every now and again, sometimes they would say, yeah, vacant possession except for the tenants, kasi yung iba, they're fine with letting the tenants carry on. That comes with its own set of risk and advantages and disadvantages. That can happen, but just keep a lookout at that. The normal protocol dito vacant possession. So, karamihan may mga nag-aaway, from our experience, nagkakaroon ng dispute dahil vacant possession ang condition, pero may mga iniwan na mga rubbish mostly, or may iniwan sila na furnitures, or they really should, should pack. Meron na, I think from experience, may, alam mo yung mga inflatable swimming pool, iniwan nandun. So, be very careful about that. So, basahin, pag vacant possession, dapat wala yung mga ganon. Goods, rubbish, occupiers, asawa, etc. Bawal iwan sa ating bahay na binenta. Number 3, without prejudice. W for without prejudice. Without prejudice is a term used in UK law to describe statements made in a genuine attempt to settle a dispute that cannot be used in court as evidence against the party at that time. That is true. So you will see often that when we lawyers make an offer to settle, literally dun sa letter nalagyan namin ng without prejudice, save us the cost. So without prejudice, save us the cost. So the reason for that is sometimes we may give in a little bit to something, or sasabihin namin, no, actually willing kami pag-isipan to. I think that's the reasoning behind that. But sometimes it's not really because sa tingin mo mahina yung kaso mo, o sa tingin mo wala kang laban. Minsan lang talaga, you know what, I'm willing to take a discount. Pero kung hindi mo pa rin tatanggapin, willing pa rin ako to go all the way. I will sue you, for example, £50,000. Pero if you accept this offer now, I'm happy to take £40,000. So you'll put that as a without prejudice settlement offer. The reason for that is yung final judge, just in case hindi kayo nagkaareglo, the judge at the trial, the final hearing, bawal basahin yon para hindi magkaroon ng predisposition yung judge na yon. Kasi pag nakita niya yon, kung hindi, kung i-allow yon, baka sabihin niya, ay, willing ka naman pala tumanggap ng 40,000. So that's the reason why those correspondences without prejudice, the best practice is lalagyan mo talaga ng label na without prejudice. Hindi po kasama yan sa trial bundle. And that will allow people, or maeengganyo yung mga tao na mag-enter into negotiation. Dahil nga, hindi pwede pa rin nilang ma-preserve yung open position nila. Kahit sa tingin nila malakas ang ebidensya nila, pwede pa rin ma-preserve yon kung gusto nilang matapos na yung pag-aaway ngayon din. So that's the reasoning behind that. Kasi ayaw nilang isipin nung later on ng judge, so okay lang naman pala sa'yo na 40,000. So 40,000 na lang yung ibibigay ko sa'yo. However, without prejudice correspondences can be opened later on. Kaya nga yung full name nun, without prejudice, save us the cost. Kasama yung middle name at last name niya. Without prejudice, save us the cost. Because you can say to the court later on, nag-offer na ako 5 months ago. I said to them, tatanggap ako 10,000. Tingnan mo, ikaw nga judge, later, so normally where it happens is you made a better offer kesa yung inano sa judge. Yung judge sabi, you know what, inofferan na kita ng, halimbawa dito, nanalo ka ng 45,000. In another, kung ikaw yung defense, kumbaga, 50,000 yung hinihingi, 40,000 nag-offer ka na kasi nga sabi mo, hindi yan tama. Hindi naman tama yung kiniklaim mo, masyado mong in-inflate. So, you make an offer without prejudice offer, sabi mo, you know what, 40, sa tingin ko 40,000 lang yung mapapanalo mo. And then it turned out na later on, ang napanalo lang pala sa korte, di niya tinanggap, napanalo sa korte, 35,000 lang. So, pwede mong ipakita yun sa korte to say how reasonable you are. Sabihin mo sa judge, mas malaki pa, mas generous pa nga ako sa'yo. I made the offer 6 months ago. Ano yung consequences nun? You can, kahit na ikaw yung technically natalo, you can claim cost. You can actually say na, I've done better. Mas nagbigay ako ng, mas naging reasonable ako. So that could have caused consequences. The thing to take away dun sa W natin without prejudice is pwede kang makipag-areglo without hurting your open position, yung totoong yung position mo na ilalan mo talaga siya. At pwede mo yan maging alas later on. Kahit na hindi yan makikita ng judge sa main trial, pwede yan gamitin para makakuha man lang ng cost kung ikaw ay napaka-reasonable. So that's something to think about. Number 4, quite excited about this because this is exsidious, or spelled Xydhias. This is a very specific term in family law. And this is from a case actually of Sidious and Sidious. So ang statement na binigay ko is an agreement reached between you and your spouse to your financial agreement, which is not yet a court order, yun ang operative term, hindi pa court order, but you may be bound to. So, baka sabihin mo, di ba attorney, dapat court order yan bago maging full agreement. Or one might say, paano yun? Nag-agree naman kami. That statement is generally true, but I will give a longer explanation kasi very technical to. So, step back muna tayo, rewind, with court agreement, with financial agreement sa divorce. I always say na kailangan mo ng court order para magkaroon ka ng clean break. Kasi sa financial agreement, isa lang ang makakapagbigay ng court order sa iyo na may sealed consent order. Isa lang, isang organisasyon, korte lang. Judge lang ang makakapagsabi, forever and ever, wala na kayong claim sa isa't isa. And that means clean break. So, sa judge mo lang makukuha yon. Sometimes, mahaba yung proseso na yan, getting to that point na magkakaroon na kayo ng agreement. You reach a point na drafted na lahat, andun na yung heads of terms, yung main na agreement nyo, pareho kayo may abogado, pareho kayong nagkaroon ng legal advice, pareho may full disclosure, and almost klaro na kung ano yung napagkasundoan nyo, ipapasa na lang sa judge, or na magpapasa ka na lang talaga. At minsan, syempre, may mga delay, baka na-delay lang sa post, o na-delay dahil may strike, yung Royal Mail. Tapos may isang party na biglang nagsabi, you know what, ayoko na. Sign na yun na-sign na, papasa na lang. Biglang sasabihin niya, ayoko na, hindi ko na gusto yung agreement na yan. Wala pa namang court order. Sasabihin niya, di ba dapat wala pa court order, so hindi pwedeng clean break yan, walang court order. I don't want to go anymore, and I want to go to full trial. Pretty much yan yung storya ng Sidious na case. So they entered into a long negotiation, drafted na yung heads of terms, may agreed heads of terms na essentially all the agreed points, and then may umatras yung husband. And sabi niya, nope, wanna go to full trial. The court says in this instance, kung ganun na halos hinog na sa ating Pilipino, hinog na yung negosasyon nyo, kulang na lang talaga, almost like yung sealed order na, ang tawag dyan, may Sidious agreement ka na. And you're likely to be bound by that. However, may mga other agreement na hindi Sidious agreement. Yung sinasabi, attorney, nag-usap kami ng asawa ko many years ago, pinag-usapan lang namin, hatiin lang namin yung bahay. But wala kayong disclosures, wala kayong abogado, hindi nyo alam kung hindi kayo nakakuha ng legal advice, hindi nyo nakita yung disclosure, as I've said, hindi nyo nakita yung disclosure ng isa't isa, hindi na type up yung heads of agreement, hindi na check ng abogado, hindi yon Sidious agreement. Iba yon, hindi yon. That's unlikely, you're unlikely to be bound by that. Kasi hindi kinog, hindi kompleto. Compare dito kay Mr. Sidious and Mrs. Sidious, na andun na, papasa na, pass the paper, kumbaga nasagutan na yung 1 to 10, papasa na lang, biglang humindi pa. Sabi ng korte, bawal. Hindi pwede yun. You're gonna be bound by that. And the court proceeded then on to say, to formulate this legal principle around that case. And that is called a Sidious agreement. Very, very specific in family law. So yeah, that's number 4. It is true, pero kailangan andun yung buong explanation. Okay? Number 5, why for yardstick of equality? It means that all matrimonial financial cases will always have an award of 50-50. That is a myth. Not always. What yardstick of equality means is yun ang starting point. 50-50 ang sa consideration starting point. Ang analogy na binibigay ko dito is, kung naalala niyo po yung sinaunang weighing scale, yung ilalagay niyo sa gitna muna, tapos i-move mo left or right. So parang ganun din sa ating yardstick of equality. The law says it starts there, but it can be more for somebody else if there is a good reason from departing from 50-50. So, ang unang titingnan muna ay kung reasonable needs are met, as well as na-cover na yung para sa mga bata, childcare ng bata, day-to-day living cost. So, that's called needs. And then we have this principle of sharing, and then thereafter, the principle of compensation. Quite simply, what it says is that mag-uumpisa man sa 50-50, pwede, pero pa yung abogado mo pwedeng mag-argue na mas malaki sa 50-50 yung makukuha mo kung na-tick na yung mga boxes na yun. Kung meron okay na, reasonable needs na, nag-share na kayo, at sabi mo, hindi, lahat na ano, pero yung sobra, akin yun. Kasi ako, a lot of reasons, maraming mga technical arguments dyan. The usual technical argument is ikaw naman yung nag-contribute, extraordinary contribution. And that was probably what they used in the case of Paul McCartney and Heather Mills. So that was okay kasi malaki yung asset ni Paul McCartney. So sabihin, no, start sa 50-50. Sasabihin ni Paul McCartney, no, hindi pwede. Kasi pag reasonable needs nakuha na ni Heather Mills, which is I think what 2.5 million house ang reasonable needs niya, na-share na, and na ano na yung sa bata, malaki pa rin, di pa rin pwede 50-50. I can argue for a departure from equality. So I think, I don't know kung 15% or not, on the top of my head, definitely not 50-50 yung kay Paul McCartney. I think it's more like 80-something or 70. Look it up if you're a law student. That's how they apply the yardstick of equality. Start doon, and then you adjust. You adjust depending dun sa argument. That's, in my head, that's how I imagine the yardstick of equality. So myth po yun. Number 5 is myth. Number 6, Z for zoning. Z for zoning is a term we use in non-occupation proceedings for splitting the areas of the house to manage the occupation of two separate spouses to avoid conflict. That is true. So, siguro yan I would consider as a family law. Hindi naman slang, pero really very, very unique way of using the zoning word sa family law. So sometimes we would medyo nagkakaroon ng friction ng mag-asawa na maghihiwalay na, pero hindi pa masyado afford mag-move out ng isa. Sometimes how we settle it is we say magzo-zoning tayo. So ikaw doon ka sa kwarto dito, ikaw doon ka sa kabilang kwarto. Sometimes we would even manage the use, i-schedule lang yung use ng kitchen. So sabihin naman, ikaw, ito yung time mo sa kitchen, ito yung allocated sa'yo. This is temporary, but this is more of how ito yung mga terms na ginagamit namin. So we would call that zoning, the zoning solution. So zone west wing or east wing sa'yo, so if we've got a mansion, or the zone or the schedule of this particular space in the house is yours. So that's how we use it. Number 7, nasa Latin terms na tayo. Ad hominem is a perfume. It isn't. That's a myth. Ad hominem is a criticism, is in a way directed against a person. It's an attack directed against the person rather than the position they are maintaining. So sometimes we use that in law. So sabihin namin na di mo naman inaatake yung legal position. Masyado ka nang namimersonal sa atin pa. Pinipersonal mo. It's an ad hominem attack. So that is myth. Number 8, bona vacancia, which means vacant goods and is the name given to ownerless property which by law passes to the crown. Okay, King Charles III. That is true. At you might ask kung kailan nagkakaroon ng bona vacancia goods. So one case na quite normal dahil nakakalimutan. So merong company, akala nila nakalimutan na yung isang property. Sometimes nakalimutan yung bank account, may maliit pa pala o may money pa pala natitira doon. Then that company proceeded to stop trading and liquidate itself, wind itself in the company's house. So according to the company's house, patay na yung company. Pero may pera pa sa bangko. Technically bona vacancia yon, mapupunta sa crown. But additional tip, meron kang way to still claim for that. I think when I was a younger lawyer, I used to do a fair bit of bona vacancia cases. May mga ganyan, nakailang case na rin ako na nag-apply ako sa korte to resurrect the company purely para i-claim lang yung mga bona vacancia property niya. So that's quite an interesting little area of law. Number 9, caveat emptor. Empty goods, that is a myth. Caveat emptor or buyer beware sa English. The principle that the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. Ibig sabihin nun, buyer daw ang mag-check. Ikaw ang mag-check. Ikaw ang bahalang mag-check. But obviously, subject yan sa implied terms ng Supply of Goods and Services Act. But that is a principle that you will probably hear a lot sa conveyancing when also doing property. Bibili po kayo ng bahay dito sa United Kingdom, they might say to you, buyer beware. Ikaw mag-imbestiga kung ano yung state ng bahay na yan. So that's probably where you will hear that term. And finally, letter D, de minimis, which is in relation to law. The term de minimis is taken from the extended Latin phrase de minimis non curat lex, which translates to the law cares not for small things. That is true. De minimis is a legal principle which allows for matters that are super small scale or insufficient importance to be exempted from a rule or requirement. It can be used by the courts as an exclusionary tool to dismiss trivial matters from litigation. So sometimes they might say kung may de minimis principle is masyadong hindi na ganun ka, it's really, really so trivial that they will say, no, we won't consider it. So that's where you hear that. I will point that out to I will link that sa isa sa number 2 natin sa vacant possession. So I said na kung may naiwan, bawal vacant possession, bawal yung may naiwan ka na goods, rubbish, tenants, etc. But this rule can be subject to de minimis principle. Halimbawa, may naiwan lang na piece of paper. Ito, naiwan. Naiwan. Siguro nakalimutan lang, may final checklist yan. Nakalimutan. So sabihin mo, technically, sabihin mo, di vacant possession yan, I will claim for that. You know, that piece of paper is infringing on my enjoyment of the property. The court might say, nope, we won't deal with that as a matter of de minimis because it's so trivial that we really would not want to consider that as a claim. So that could be the de minimis rule applied to number 2, vacant possession. Very quickly, let's just double check. Number 1 is myth. Number 2 is true. 3 true. 4 true. 5 myth. 6 true. 7 myth. 8 true. 9 myth. And 9 true. That's our part 3 probably final round for a while. Baka magkaroon tayo ng Latin terms on its own later on. Mr. Laragan.